All right, well, we'll get things started. I know folks are still rolling in, but I want to welcome everyone to the Network for Public Health Laws webinar, Potential Changes in Federal Cannabis Policy and the Anticipated Public Health Impacts. Thank you for joining us. I'm Matt Swinburne. I'm a senior advisor at the Network for Public Health Law, and I am a public health attorney who focuses on the impacts of cannabis legalization on public health. I am joined today by my colleague, George Townsend. George is a staff attorney at the other organization I work with, the Legal Resource Center for Public Health Policy. And we're going to be addressing a couple important issues today related to federal policy. Now, before we get into the substance of today's webinar, there are a couple housekeeping items I want to go over, which will hopefully help people stay focused. Now, with our webinar today, the presenter slides, as well as the recording for the webinar, will be available on the network's website within a few days after the webinar, and you will receive an email notifying you when they've been posted. So these slides will be available to you after the webinar. Now, we have a lot of people signed up today, and with registration, a lot of folks submitted questions, but we're still, we want people to ask questions. So during the webinar, please use the Q&A function to post your questions. And at the end of our presentation, George and I will answer as many questions as we can, but with a group this large, it's going to be difficult for us to get to all of them. So next slide, please. All right. Oh, here are glamour shots. I look much younger in that. Kayleen, thank you for using that one. Makes me look young. Now, if we could advance to the next slide. And the next slide. All right. So today we're going to be talking about federal cannabis policy and some potential changes. But to give some context, the majority of Americans live in states that have legalized cannabis either for medical use or medical and adult use. And so we've provided a map here that shows the change in policy. The states in kind of the orange color are states that have both medical and recreational cannabis, and those in green have legalized cannabis for medical use. And so we have this conflict. Well, currently, cannabis is a Schedule I substance under federal law, which means it is illegal under federal law. So with this conflict, the majority of cannabis policy is happening at the state level. So all of these states are developing laws and regulations around the cannabis industries and cannabis use in their jurisdictions. However, there are two big changes that are being discussed at the federal level, and I'm sure some folks have heard of one or two of these. And we're going to start off with George presenting on the potential rescheduling of cannabis from a Schedule I substance to a Schedule III substance. And George is going to discuss the process and what that would mean from a public health perspective. And the other item we're going to cover, once George is done, I am going to talk about intoxicating hemp products and what the federal government is looking at with the Farm Bill and some other legislation that would look to regulate or restrict these products. So with that being said, I'm going to pass it over to George and ask Kayleen if you could advance the slide.
All right. Good afternoon, everyone. Thank you so much for being here. It's great to be able to meet with so many interested and engaged individuals to talk a little bit about the process that we're currently seeing to reconsider the federal scheduling of cannabis, and then talk about a few other issues and potential areas for federal policymaking in future cannabis on future cannabis matters. So let's hop right in with the next slide, please. All right, so we're going to get started talking about rescheduling. Anyone who is following cannabis news actively is probably aware of at least some part of the information that I'm going to be getting started with today. So please bear with me as we go over sort of the entire process from beginning to end, just so everyone sort of understands the framework we're referring to here. So today we're talking about federal cannabis policy. Now, cannabis has been regulated along with several hundred other drugs under the Controlled Substance Act of 1970. So this was a sort of broad overhaul of federal drug regulatory policy that was enacted in the 1970s to sort of synthesize and make uniform all the sort of disparate drug regulations and restrictions that existed prior to the 70s. So when the CSA was passed in 1970, it created a system of 5 schedules. And these 5 schedules are based on the potential of various substances for abuse, whether or not those substances have a currently accepted medical use, and then the risk that each substance poses for dependence by users. And then each of those 5 schedules is subject to a different set of regulations from the federal government based on how that substance satisfies these 3 factors. So, in 1970, 5 schedules were created. From the very beginning of the Controlled Substances Act, cannabis has been scheduled at Schedule 1. This has not changed at any point in the last 54 years. I put up here on the screen a small handful of other Schedule 1 drugs, so you can see some of the other substances that have been grouped into this category. So heroin, LSD, mescaline, peyote, and psilocybin are all also scheduled at Schedule 1. Schedule 1 is considered the highest level of regulation. These are the drugs that are the hardest for an individual to get and to use under the CSA. These are drugs that are considered to have a very high potential for abuse. They are considered to have no currently accepted medical use, and they are considered to have a very high risk of dependence. So again, based on the understanding of cannabis that the federal government had in 1970, it was put into Schedule 1 of the Controlled Substances Act. And despite several attempts over the past 54 years to change that, as of today, it is still currently listed in Schedule 1. It's important, though, that I point out at this stage of the presentation that there are some medications containing cannabinoids, which are chemicals derived from the cannabis plant, that are scheduled differently. So the 2 that I have highlighted here are forms of dronabinol. Syndrose and Marinol are, I believe, the brand names of those medications. Dronabinol is a synthetic cannabinoid, so it is synthetic THC. THC, again, for anyone who's not aware, tetrahydrocannabinol is the main psychoactive substance that is derived from the cannabis plant. Specifically, delta-9 THC is a specific isomer of THC that is the most sort of potently psychoactive, and where the high of consuming cannabis comes from. Dronabinol is a synthetic form of delta-9 THC, and there's 2 different formulations, Syndrose and Marinol, that are scheduled differently. So Syndrose is currently a Schedule 2 drug, which means it has some currently accepted medical use and a slightly lower potential for abuse and risk of dependence than a Schedule 1 drug. And then Marinol, which is Schedule 3, that has an even lower potential for abuse and risk of dependence, and also a currently accepted medical use. So even though cannabis, as sort of a broad umbrella term of the derivatives of the cannabis plant and sort of synthetic forms of cannabis-derived chemicals, is as an umbrella put in Schedule 1, there are specific medications derived from synthetic cannabinoids that are scheduled differently. There is also a third FDA-regulated medication, which is Epidiolex, which is a a medication that's based on CBD, which is another cannabinoid. It's not psychoactive in the way that THC is. CBD is non-psychoactive, and one formulation of it, Epidiolex, which is derived from the cannabis plant, has been approved by the FDA as a medication for childhood seizures, certain seizure conditions affecting primarily children. Epidiolex was for a time scheduled at Schedule 5, which is the very lowest schedule on the CSA, and has since actually been removed from the CSA schedules entirely. So it's now regulated entirely outside of the Controlled Substance Act regulatory program. So what we're seeing is, again, just to take a big step back, cannabis, the plants, and its derivatives are grouped in the highest level of control under the Controlled Substances Act. But there are two synthetic medications that use synthetic versions of cannabinoids that are scheduled at slightly lower levels, and then one non-psychoactive medication that is completely removed from the scheduling system that is derived from the cannabis plant. All right, so that was a lot of context. Let's go to the next slide to see where we're at currently. So for those who have been following cannabis news at all, you've likely heard that the Drug Enforcement Agency and the FDA, or Drug Enforcement Administration, excuse me, and the FDA are currently in the process of considering a change to DEA rules that would move cannabis from Schedule 1 to Schedule 3. So under the CSA, the DEA has the power to use its administrative rulemaking process to move a substance from one schedule to another, or to remove a schedule or a substance from the schedule system entirely. Earlier this year, the process was sort of formally initiated to reschedule cannabis at a lower level. This would have pretty significant implications, which I'll get into on some of our future slides, regarding the availability of cannabis to researchers, the steps that a clinician would need to take to obtain cannabis for something like a clinical trial. However, it's very important to note that at whatever schedule a substance is categorized, for it to be available to the public for personal possession and use, it still has to comply with other federal regulations, most notably the regulations on prescription medications imposed by the FDA. So rescheduling cannabis would have some impact on the availability of cannabis for researchers who are looking to develop new medications. It would not legalize cannabis, certainly for recreational use, and it would not sort of backdoor a lot of state medical cannabis programs into sort of federally sanctioned programs. The primary difference that would occur at Schedule 3 compared to Schedule 1 is that the ability for researchers to obtain cannabis would be significantly expanded. So Schedule 1 drugs are very, very tightly regulated by the DEA. The specific amounts of each substance that are allowed to be produced is subject to very strict quotas. So people who want to produce any of those Schedule 1 substances for research purposes is subject to very, very strict controls, which is why there's not very much research that is done into the medical application or the effects of those drugs. Schedule 3 drugs, on the other hand, there are still very close regulations of who is allowed to produce those drugs, who is allowed to possess them, what purposes they are allowed to be used for, but they are less stringent and there are less strict quotas. So researchers would presumably have a much easier time getting their hands on cannabis products that they could use then in clinical trials to determine what, if any, medical uses they can find for cannabis and cannabis-derived THC medications. All right, next slide, please. So let's talk about what this process actually looks like. So under the Controlled Substances Act, To initiate the process, the FDA, the Food Drug Administration or agency, has to send over a recommendation to the Drug Enforcement Administration recommending that cannabis or that any substance be moved to a different schedule. And in this case, in August of last year, the FDA sent over a recommendation with a collection of findings reviewing the science on cannabis, showing that there was pretty substantial evidence that cannabis is being used for medical purposes, showing that it has a currently accepted medical use, and reanalyzing the potential for abuse and the risk of dependence of cannabis, and reaching a sort of preliminary finding that cannabis would likely be better suited for a Schedule 3 scheduling than its current Schedule 1 designation. So this is just a finding of facts and a recommendation that is sent over from one federal agency, the FDA, to the DEA. Doesn't have any sort of direct impact on the law as it currently stands. It just starts this rescheduling process. The next step happened earlier this year in May of 2024, which is that the Department of Justice, which is the broader agency overseeing the Drug Enforcement Administration, published their notice of proposed rulemaking to reschedule cannabis. So I really don't want to get too deep in the weeds here of federal administrative law, but if any federal agency wishes to change its agency rules, there's some very complicated steps that have to be taken. In the case of a rescheduling, there is what's called a published notice of a proposed rule making or rule change. So essentially, the Department of Justice was required to write up a proposed change of agency rules that would put cannabis in Schedule 3 instead of Schedule 1, and to publish it in a manner that would be accessible to the public so that everyone living in the US can read it and then tell the federal government what we think. So for a period of about 3 months, from May to July of this year, that notice of proposed rescheduling was publicly accessible, and over 40,000 individuals read it and responded to it. So there were over 40,000 public comments that were submitted to the DEA responding to this this proposed change. I'm going to be honest, I have not read all 40,000, but suffice it to say, there was a pretty wide range of perspectives. There were a lot of people who were very much in favor of rescheduling cannabis. There were a lot of people who were very opposed to rescheduling cannabis. There were a lot of very nuanced opinions that reflect different aspects of the rulemaking change. And to be honest, there were some very unnuanced opinions as well. So a very broad spectrum of feedback was sent to the DEA. Following the receipt of these public comments, the Drug Enforcement Administration decided it was going to have a hearing on the record to hear further evidence and further develop the evidentiary record that the Drug Enforcement Administrator will use in making the ultimate decision whether or not to adopt this rule. So that hearing is currently underway. On December 2nd, which was about a week and a half ago, the administrative law judge had the very first hearing, which is basically an opportunity for the administrative law judge to meet with all of the representatives who were selected to participate in this hearing and to essentially get a sense of what evidence they're going to present. The actual sort of fact-finding process is going to be getting started in January. I had the date written down. Unfortunately, I put my calendar away. Bear with me for 1 second. We're going to get started on January 20th, I believe, is when they've scheduled to start the process. And then they're going to be hearing testimony for about 2 months. So January through March of this year, an administrative law judge appointed by the Drug Enforcement Administration is going to be hearing from dozens of witnesses who are going to testify for and against this proposed rule change. So that's where we're at right now. Once all of those very many witnesses have had the chance to testify, the administrative law judge is then going to put together a report of his findings based on that testimony, which will then be submitted to the administrator of the Drug Enforcement Agency, who will then be tasked with making an ultimate decision and implementing a final rule, which will either move cannabis from Schedule 1 to Schedule 3 or leave it where it's currently at Schedule 1. All right, next slide, please. So a little bit more details on the DEA hearings. I went over a little bit of this already. The primary one thing that I think there's a lot of confusion about the hearing is that when people talk about it, they tend to talk about it as if it were a trial, which is sort of a very new, like a court case that's there's a neutral judge who's hearing the one representative from one sort of attorney representing the plaintiffs and one attorney representing the defendants, and they're sort of on equal footing here. In this case, it is an administrative hearing. So there is an administrative law judge who is selected by the Drug Enforcement Agency. And the main sort of proponent of the rule is the Drug Enforcement Administration, who serves as the proponent of the rule. And they are tasked with presenting the evidence that supports the administration's proposed rule change. There are, I want to say 20 some, I think 24 or 25 other parties who have been invited to participate. As you can imagine, not all 40,000 individuals who weighed in on cannabis rescheduling were invited to participate in the hearing. The Drug Enforcement Administrator was tasked with sort of narrowing down the list of potential witnesses to those who are most impacted by the rule. The purpose of the hearing is just to develop a factual record of evidence. So each proponent and opponent of the proposed rule change will have the opportunity to call either one or two witnesses who will appear before the ALJ and present their testimony. They've been given 90 minutes to 120 minutes each just to make their case. And then all of the very many attorneys representing the different parties involved in the hearing will have the opportunity to do some cross-examination, which will, I assume, take up the majority of the hearing's time, because that sounds like it would be a very lengthy process. But again, the whole purpose of this hearing is just to develop a factual record, and then the judge is tasked with submitting a report to the DEA administrator with a summary of findings of fact, conclusions of law, and a recommendation for what the administrator should ultimately end up doing on this proposed rulemaking. All right, next slide, please. So what would the actual change be for us ordinary people living our ordinary lives if cannabis was moved from Schedule 1 to Schedule 3? I mentioned a little bit of this earlier, but I want to take a second here to drill down more specifically on what would actually change. And the long and short of it is, in general, not very much. So drugs that are scheduled at Schedule 3 of the Controlled Substances Act are not just completely deregulated stuff you can just buy at like a grocery store. Schedule 3 drugs must still be prescribed to an individual by a registered healthcare provider. So a doctor or some other healthcare provider who is a registered prescriber of controlled substances under the Controlled Substances Act. For any medication to be prescribed through the system, the formulation of that medication has to be approved pursuant to the Food, Drug, and Cosmetics Act. So even if cannabis is moved from Schedule 1 to Schedule 3, that doesn't mean that you can prescribe someone just like a bong hit that's not a prescription medication. There could be medications derived from botanical cannabis that are formulated in a manner that can be tested by the FDA and approved for prescription under the Food, Drug, and Cosmetics Act, but they would still have to be formulated as medication with very precise formulation showing sort of the exact chemical content of that medication and with very strict sort of limitations on things like potency and dose. The main change that I foresee coming about as a result of rescheduling, is that Schedule 3 drugs are just significantly easier to manufacture and obtain for approved scientific purposes, which I'm referring here to things like clinical testing and trials. Unlike Schedule 1 drugs, which are subject to extremely strict and limiting manufacturing quotas, Schedule 3 drugs are just slightly easier for researchers and institutions to obtain for clinical trials, which I expect to lead to, hopefully, a significantly greater amount of clinical research and studies showing the effects of cannabis in a controlled clinical setting and researching the potential medical applications of cannabis. We're seeing a lot of this research happening now under state systems, but federal regulations are restricting a lot of researchers who would like to be doing more research into cannabis's use and effects. So what would not change? For one thing, Schedule 3 drugs are not legal for recreational use. So every state that has a recreational market that would not be sort of sanctioned by federal law, as it's not currently sanctioned by federal law. States that currently ban recreational use, that would not change at all by rescheduling cannabis from Schedule 1 to Schedule 3. And then I note here that medical use of Schedule 3 drugs that occurs outside of that Food, Drug, and Cosmetics Act approval process would still be prohibited. So, for example, in the state of Maryland, where we work, we have a medical cannabis system, and there are certified healthcare providers who can certify a person to possess and use a certain amount of cannabis products for medical purposes. That is done by a medical expert who has experience and expertise with cannabis science and cannabis pharmacology. But it's important to note it is a certification. It's not a prescription. It is a system that is sanctioned by Maryland law, but it is not compliant with this FDCA federal regulatory process. So it would still be a separate system that would exist outside of whatever medication is developed and approved under the FDCA process. All right, next slide, please. All right. Last but not least, before I turn things over to Matt to talk about hemp, I did want to very briefly talk about federal cannabis descheduling. And this is just sort of a part of the presentation where I'm going to talk a little bit about what the federal government could choose to do in the future if it wished to, which would be to reconsider the way the federal government regulates cannabis entirely by removing it from the Controlled Substance Act. And I think when most of us talk about like federal decriminalization, what we're talking about is really descheduling, not rescheduling. An important signpost I want to put up here. When we talk about rescheduling, everything I went over earlier, that is a process that is currently underway, and it is something that we are likely going to get, that matter is likely to be resolved sometime in the year 2025. Federal cannabis descheduling, which would be removing cannabis from the Controlled Substances Act altogether and regulating it separately, is something that has been proposed several times over the last decade or so in Congress. It is not something that there is actively a lot of political will to get done imminently. So while it is something that could be considered by Congress in the future, it's not something that I think we're going to see in the next 6 to 12 months. So I'm just giving you information about it so you're aware of what the possibilities are, not to indicate that this is something you need to have on your short-term radar. But I do want to get into it. So let's hop in. Next slide, please. So when we talk about descheduling cannabis on the federal level would involve removing cannabis from the Controlled Substances Act schedules altogether and regulating it as a separate substance. What sort of precedent do we have for this? Well, I think it's important to note that when the Controlled Substances Act was created in 1970, from the very beginning, the CSA did not regulate two very common and very important substances, which are tobacco. So two substances that have psychoactive effects, have a high potential for dependency and abuse, but are not regulated under the Controlled Substances Act. Alcohol and tobacco are both regulated by rather than being assigned a slot within the 5 CSA schedules. So, if the federal government would chose to decriminalize cannabis, What that would likely entail would be to remove cannabis from the CSA entirely and create some sort of alternative regulatory program allowing cannabis products to be sold without having to be prescribed under the sort of Food, Drug, and Cosmetics Act process. What would this entail? Well, because we're talking about hypotheticals, it could entail hypothetically anything. What it could look like would be the federal government choosing to create sort of a recreational cannabis market, similar to what we see in many states that have legalized recreational cannabis. It could mean the federal government created something that looks more like state medical cannabis programs, where an individual can sort of get a physician's certification for cannabis products that maybe don't comply with FDCA prescription medication formulations, but are nevertheless require some sort of physician's note to acquire. Because this is the type of process that would likely have to be initiated by the United States Congress, whatever way Congress chose to regulate these products would likely be what was imposed. There have been a lot of bills to this effect that have been proposed over the last decade or so. I didn't pull any one or two out to serve it as an example because none of them have passed both chambers of Congress, and there's no sort of one definitive model that has been sort of the most prevalent of the proposals that have been put forward, which is again why I'm sort of flagging here that there's no sort of one uniform set of regulations that have a lot of political will behind it that I would expect to see rolled out in the next year or two. This is something that some members of Congress are thinking about, and we may see more proposals put forward in the next decade or so. But what that looks like could depend on what Congress wants to enact. Next slide, please. Mostly this slide just goes over what I already discussed. It is important to note here that federal law has the power to preempt local laws. So if the federal government chose to create a nationwide system for regulating cannabis, the United States Congress could choose to impose that restriction on all states, including those that already have their own state cannabis markets. And it could absolutely, if it wishes to, override local systems, or alternatively, it could choose not to do that. So the federal government could, if it wished, adopt some sort of cannabis descheduling program that would allow states with an existing medical cannabis marketplace or an existing recreational marketplace to say, you states can do what you're already doing, keep that system in place, while imposing its own system on other states. So again, the federal government can essentially do whatever it wants in this space if Congress can sort of all agree together on one scheme that it wants to create. All right, next slide, please. Last but not least, I do want to talk about some of the benefits and then some of the downsides of having a national cannabis marketplace. For one thing, if the federal government did choose to create sort of a nationwide regulatory program for cannabis products, that would allow for a nationwide standardization of regulations across the country, and it would allow federal and state governments to collaborate on enforcement matters. So just a greater uniformity. It would ensure that there aren't any sort of loopholes where maybe one or two states are regulating cannabis markets poorly, because all states would be using a similar standardized set of regulations. One other issue that we've seen cropping up, we get a lot of questions about it here in Maryland, but it's an issue we're seeing throughout the country, is issues of sort of the environmental impact of cannabis agriculture, which is that currently we have each state that has legalized cannabis tends to require, or does require, that the cannabis bought and sold in that state is produced in that state. Part of that is a requirement of federal prohibition, because the federal government has prohibited the cannabis, the sale and possession of cannabis. It is illegal for cannabis to move in interstate markets. So cannabis cannot legally, under federal law, cross state lines from one state into another. This means that a lot of states that are not particularly well equipped to for the agriculture of cannabis, nevertheless have their own local industries as local growers and farmers produce cannabis for sale to the local market. And what we've seen is that there are a lot of states where it's just very hard to grow cannabis outdoors. And what these states have done is that they've had a lot of indoor cannabis cultivation, which allows cannabis to be grown year round in indoor facilities. But it has downstream effects of being extremely energy consumptive. It uses a lot of electricity to keep, lighting to facilitate the growth of cannabis indoors. It can also have a lot of impact on water usage. Cannabis could be a pretty thirsty plant and consume a lot of water. If there was a nationwide cannabis market, it would allow for states that have a more cannabis-friendly climate to produce more cannabis that can then be shipped to states where it is less efficient to produce it. So it would resolve some of our environmental impact of our current state of cannabis cultivation. Next slide, please. What are the downsides then? Well, for one thing, if the federal government were to choose to preempt all state cannabis marketplaces, it would disrupt some of the regulatory systems that are currently in place in states that have legalized cannabis. Obviously, each state that has legalized cannabis, whether it's recreationally or medically, each of those states have their own local regulatory scheme that they use. Some of them are more effective than others, but some states are very happy about how they've been able to regulate their cannabis marketplaces, and they may be a little bit upset if the federal government would come in and require them to change up the way that they regulate cannabis. So sort of federal oversight may be beneficial for some states that are struggling, but may be seen as harmful by some states that feel that they're doing a great job with their current system. Another thing that's important to note, I talked moments ago about the benefits of having a large-scale nationwide cannabis marketplace, but there would also be some downsides as well, which is that a lot of state cannabis legalization movements have prioritized putting money and investment into specifically local communities that were harmed by the law enforcement techniques of the war on drugs. And so they specifically have prioritized putting money into local communities as a way of repairing some of that damage. If cannabis were, like cannabis production, were to be moved out of the states where it's currently happening and into states that are a little bit more cannabis climate friendly, that would undermine some of the attempts that are currently in place to move that cannabis industry money into specific communities within specific states. So it'd be harder for states to control where the profit of the cannabis industry is getting directed. And next slide, please. All right, so that was a lot of information. Thank you for bearing with me. I know we've got a lot of questions, so we will circle back to those at the end here. But Matt is going to be going over for us some of the issues related to hemp products, which is just as complex as federal rescheduling. So I will turn things over to him.
All right. Thank you for that great presentation, George. I'm going to talk today about the explosion of intoxicating hemp-derived products that we're seeing across the country. And these are products that are often, being sold in smoke shops, corner stores, gas stations in some jurisdictions. And the level of regulation of these products really varies from state to state. And some of these intoxicating hemp-derived products are as potent or more potent than the products that are sold within states' licensed cannabis markets. And so I'm going to give a little background about what hemp is and the legal structures that the federal government has put in place, and kind of explain the challenge that many public health communities are seeing. Next slide, please. All right. So what exactly is hemp? Well, hemp is the cannabis sativa plant, so the same plant that is used in our licensed cannabis markets, but it has a lower natural potency, meaning that there is a lower level of THC in the plant. Now, in 2018, the agricultural bill or the farm bill legalized the hemp plant as an agricultural product. Now, hemp prior to this was a Schedule 1 substance. So this change in the Farm Bill removed it from the Controlled Substances Act completely. So it was no longer restricted for research, and it permitted interstate commerce of the hemp plant. And the federal government set some cultivation standards for the growing of hemp, but it allowed states to create their own cultivation programs if they wanted to, as long as they were as protective as the federal program. Now, we have some issues regarding products that are made from hemp and how they're regulated. Now, a key thing in this farm bill is it said, FDA, you retain your traditional authority to regulate products. So you can regulate the products that are made from hemp. So FDA has authority over food, dietary supplements, dietary ingredients. So this is an important thing to remember as we move forward. Next slide, please. So how are we getting these products that are being sold in corner stores, gas stations, and smoke shops that are, intoxicating products that are very similar in many cases to the products that are sold in our licensed dispensaries? Well, I'm going to joke around and say something that I like to say is that Congress was bad at math and science when they wrote this bit of legislation regarding hemp. And so the first thing we need to look at is how they defined hemp. And so you see here that it is the cannabis sativa plant and any parts of the plants, and essentially all the products that are made from that plant, as long as they have a delta 9 THC concentration that does not exceed 0.3% by dry weight. And as George mentioned in his presentation, THC is the primary intoxicant in cannabis, and delta 9 is the form that is usually in highest concentrations naturally in the plant. And we're going to get into some of the other forms of THC in a little bit. But this equation that they use to set the THC cap for products made from hemp, I think had some unintended consequences. So let's apply that equation to a Snickers bar. So a Snickers bar weighs around 50 grams. Now you could infuse that Snickers bar with THC, delta 9 THC from the hemp plant of up to 150 milligrams of delta 9 THC using that restriction. Now, for folks who aren't familiar, THC's potency is not measured in grams, but in milligrams. And 150 milligrams is a high level of delta 9 THC. Most state adult use programs for cannabis restrict a serving size of THC for an edible to either 10 milligrams of THC per serving or 5 milligrams per THC. So this definition allows the creation of some potent products just by the way it's drafted. Next slide, please. So we talked about bad at math in the last slide. Well, we're going to talk a little bit about bad at science. So delta 9 THC isn't the only form of THC, but it's the only form of THC that's directly addressed in that definition. There are other isomers of THC. You may have heard of delta 8 THC. You may have heard of delta 10 THC. These are just slight, a changing of a chemical bond in THC. And these isomers of delta 9 THC are intoxicating. they're different binding potentials to the receptors in the human body, but these are substances that are intoxicating. Now, they didn't address these isomers in the legislation. So here's where kind of the bad at science comes in. CBD, cannabidiol, can be, a little heat, a little acid, some solvents, and you can convert CBD into these THC isomers. And so what we've seen with a lot of hemp products is that the hemp industry is changing CBD into THC and are selling products with Delta 8 THC, Delta 10 THC. And even if, the idea that Delta 8 THC isn't as effective to binding to our receptors in our brain as Delta 9 is, we have products with 500 milligrams, 600 milligrams in a package. So where there is less efficiency in binding, I think some of these products make up for that by the quantity of THC isomers in them. Now, the FDA, remember, has authority to regulate products made from hemp, and they haven't really done much with regards to regulation. And in a second, we'll talk about the things that they have done. But where we get a challenge is because we have these products that are also, in many cases, intoxicating products, states, the federal government hasn't created safety protocols for them, and in many states haven't developed safety protocols for them. And so this is why we're seeing them sold throughout the country at locations that are often accessible to children, like gas stations and corner stores. Smoke shops are not, accessible to children usually. But this is a really big market. The hemp market is valued at approximately $30 billion in terms of the national market. Next slide, please. So what has the federal government done to try to address some of these public health challenges of these intoxicating products that are made from hemp? Well, a couple of years ago, they issued this consumer update where they essentially warned that, Delta 8, one of these isomers had not been evaluated or approved by the FDA. And, they had received reports of adverse events associated with it. And, they're just highlighting things that this is indeed psychoactive and intoxicating. And so they just kind of issued this warning with these 5 major points. So there's kind of this public warning, but many folks, haven't seen this warning. And so there's a lot of public education that needs to happen around, the impacts of Delta 8 and other THC isomers on folks. Next slide, please. Now, the other thing that we've seen is that the FDA, in conjunction with the FTC or the Federal Trade Commission, have issued dozens of warning letters to hemp companies. And, the FDA's warnings, relate to their authority under the Food, Drug, and Cosmetic Act. And they, in some cases, have, said to these companies that you are marketing an unapproved new drug based on the claims that you're making. Your product qualifies as a drug and it's not approved, and you need to discontinue this practice. Other times, the warnings have included the issue of a misbranding, that there aren't adequate directions for the products for safe use. And we're also seeing warnings, and for my food safety folks, this is probably something you're familiar with, they're warning these companies that their products are adulterated food products and that, Delta 8 THC is not an authorized food additive. Now, where the Federal Trade Commission comes in is that they are citing these companies for unfair and deceptive marketing practices because they are marketing an intoxicating product in a way that is attractive to children, essentially making their products look like foods commonly consumed by children and packaged in that way. So we've got some warning letters, but dozens of warning letters is just scratching the surface, I think, of the public health challenge that we're seeing. Next slide, please. So, in the void of kind of any federal action up to this point, states have tried to step in and address some of the public health challenges associated with intoxicating hemp products. And the approaches vary widely from jurisdiction to jurisdiction. New York tried to create a separate licensing system for hemp-derived products, and a system that had a lot of the kind of the public health policies that we see in our licensed cannabis markets, so our legal cannabis markets and states. Oregon, you know, didn't require a license for these products, but set some product limitations and age restrictions on these products. And Maryland attempted to prohibit the sale of intoxicating hemp products outside of a licensed cannabis dispensary. So it would have prohibited the sale of these products at smoke shops, corner stores, gas stations. But what we're seeing is that state attempts to regulate or prohibit the sale of these intoxicating products are often challenged in court by the hemp industry. So, for example, in Maryland, the state is currently litigating a challenge to these hemp restrictions. And as a result, the intoxicating hemp products are still being sold at these locations throughout the state. So, you know, these products present many of the same challenges and risks that our licensed cannabis products do. Well, what are the potential resolutions for this? And really, there's two avenues for this. And it's, you know, they're going to either be addressed on a state by state basis. So, things like Maryland with its regulations in this case that's happening right now, that could potentially lead to an outcome of restricting some of the public health challenges, or we're going to have to rely on federal action. And there are a couple things happening related to these hemp products. Next slide, please. So the Farm Bill is this giant bill that is usually renewed every 4 or 5 years, but Congress is currently trying to draft a new farm bill. And there's some challenge to this right now because the previous farm bill expired earlier this year, and Congress is still battling out on what they want this very large bill that addresses a lot of issues beyond just hemp. And so this is kind of a big challenging process to get this bill passed. But the House has introduced their version of the Farm Bill, and it is very restrictive of hemp products. And it essentially would close what's been perceived at times as a loophole for these intoxicating hemp products. And with the House bill, it would prevent hemp-derived products from having quantifiable amounts of THC or other cannabinoids that have similar effects. It would prohibit essentially THC from being synthesized and added to these products, which, Delta 8 THC, for example, occurs naturally in incredibly low levels. And so these products require external synthesis, that changing of CBD into the product. So this House bill would essentially close the intoxicating hemp product market. Now, the Senate has also introduced a version of the Farm Bill, and in theirs is much less restrictive. And it does a minor tweak to the definition of hemp so that the definition would include that, the limitation that 0.3% by dry weight would include all forms of THC. So it's a much less restrictive. It would still allow these products to be made, but it's modifying that THC cap. Next slide, please. All right. There is also another bill that has been introduced, the Cannabinoid Safety and Regulation Act. And rather than looking at prohibiting these intoxicating hemp products the way the House Farm Bill does, it would allow these products to be made, but would subject them to a series of federal, essentially safety regulations. So there would be labeling requirements, warnings on packaging, restrictions on advertising so that it's not attractive to children, a prohibition on products that contain alcohol, tobacco, and nicotine. And so a lot of the tools that we see used in our state licensed cannabis markets. The key thing to remember about this is that it would allow states to ban these products. So it would still give states some autonomy over this, but it would explicitly allow them to ban these type of hemp products. Now, the challenge that we have here is that the legislative session is coming to a close. And this Cannabinoid Safety and Regulation Act is unlikely to pass, and it would have to be reintroduced next year. But this, along with the Farm Bill, so we're probably not going to have a quick resolution to these issues through either of these legislative approaches. And this is something that is going to have to be approached again in the new legislative session next year. But the fact that these bills were introduced and they're starting to look at this is a big shift in federal policy related to hemp. Whew! All right. Next slide, please. Questions. Now, I know George and I went over a lot of stuff and we got a lot of questions with registration and in some here. George and I are willing to stay on a little later and answer some of these questions because I know we're at ending time. But before we go to questions, I want to just highlight some network news. So, Kayleen, could you go to the last slide? All right. So, separate from what we're doing here today, we want to invite everyone to attend our 2025 Public Health Law Conference. And we've got information here. There's information about it on our website. And again, for folks who have to jump off in the next minute or two, just want to remind you that the recording of this webinar will be available on the network's website as well as the slides that were used today. So thank you. George, I'm going to throw some questions your way that I saw earlier. So there was one question. You went over kind of a lot of procedural, kind of rather chaotic procedure
Yeah.
for
Yes.
rescheduling. And we had one person ask that, will there be potential procedural disputes that could create grounds for legal challenges to the outcome of rescheduling?
Yes. Yeah. So if anyone is following this hearing process in the news, you've probably seen there have been it's been a lot of chaos. A lot of sort of initial motions were filed prior to the actual initial hearing that was held December 2nd. It's very likely we will see some challenges after the hearing has ended. I think that's true in any sort of important rulemaking proceeding. I will say in the current hearing, we've already got two legal challenges that have been filed as of today. One is not sort of a formal filing, but I believe about 2 weeks or so, an organization called Veterans Action Council, which is they're an organization that had applied to be involved in the hearing and were denied. They sent a letter to the DC Circuit Court of Appeals asking for the court to intervene and I guess get them instated as a party to the hearing. More formally, though, just earlier this week, an organization called Doctors for Drug Policy Reform filed a motion with the District of Columbia Circuit Court of Appeals to stay the hearing and consider what standards the DEA used for selecting the participants. So this is an organization that is in favor of the rule change, but would like to participate in the hearing and had not been selected as one of the hearing participants, who are now trying to stop the hearing so they can get some more clarification on how the participants were selected. So we already have some filings in court that it's unclear as of today whether the DC Circuit Court of Appeals is going to do anything about that motion, whether they'll choose to intervene or not. But regardless, I think we're going to see probably from both sides a little bit more chaos in the next couple months as different things get filed. But again, just because someone has challenged the proceeding doesn't necessarily mean that a court is going to halt the proceedings or anything like that. So I think it's unfortunately very hard to say right now what the exact timeline is going to look like. If the hearing goes forward as planned, the hearing itself should be wrapped up in March. And then there's, I believe, a minimum 25-day period. Probably will be longer than 25 days for the hearing, the ALJ judge to put together a report. And then that has to be sent to the DEA. So it will probably be a couple months regardless, even without any more sort of court action. Before we get a final resolution. My guess would be probably sometime late 2025, unless things get crazy, in which case, who knows?
So I don't think this will be a smooth journey to a decision. I'm going to ask you one more question before I'm going to answer a few of the questions that were listed in the chat. So
Perfect.
we had a question early on that asked, essentially, how would rescheduling affect the Drug-Free Schools and
Yes.
Communities Act and the drug-free policies that schools have to have?
Yeah, this is a great question. There are a few areas of federal law that dealing with federal programs that provide funding in a variety of contexts that prohibit individuals who use any federally illegal drugs from participating in those programs. So one of those that we see most commonly causing issues is the Drug-Free Communities, Drug-Free Schools and Communities Act. You just said it. I immediately forgot the order of the words. But it essentially requires that any educational institution that receives federal funding has to prohibit all federally illegal drugs from being used on that campus. And this includes federally funded student loans, which the vast majority of colleges and universities in the United States receive some form of student loans on behalf of students who are trying to pay their tuition, which means that even in states where cannabis is legal under state law, on universities and colleges, as long as that college or university accepts federal student loans, all drugs have to be prohibited. And as it turns out, that would likely not be changed under rescheduling. Once again, as I mentioned, rescheduling would allow, it wouldn't have very much impact on, first of all, it would have no impact on recreational cannabis use. So that would absolutely not legalize recreational cannabis use on college campuses. But it would only allow medical use if it's in the form of an FDA approved medication, which again, we already have like dronabinol or Epidiolex. Those are, again, technically, one is a synthetic THC product, one is a botanical CBD product. Those are already legal federally, and a college student could use those medications on campus, provided that they were properly prescribed and properly being used. So again, if any cannabis derivatives were to be prescribed as a FDA-approved medication, then those would be legal on college campuses. But recreational use or any sort of state medical use that is not in compliance with federal law would not be proven. And then also, I will note, we talked about college campuses. Another federal program that prohibits cannabis users is any sort of housing subsidy. So anyone who has a housing choice voucher or lives in publicly subsidized housing is also unable to use cannabis at all, recreationally, medically. Again, unless it's in the form of some sort of THC-derived medication that's approved by the FDA, a person cannot receive a housing choice voucher or live in publicly subsidized housing unless they stop using cannabis altogether or any other drug regulated by the CSA.
Yeah, I think this is just drives home the point that this rescheduling isn't, if this happens, isn't going to have a lot of the changes that people are expecting. But one of the important things that I want to point out that I know you, George, you and I and Annie talk about in our work is that any form of, at the state level legalization, the rescheduling at the federal level and descheduling at the federal level has a big public health impact in terms of people's perception of the risk associated with
Yeah,
cannabis use. And we see data on this at the state level. And so one of the things for folks to keep in mind that, with rescheduling, if this happens, there's probably going to be a change in public perception around the safety of cannabis use. And so for folks in the public health community, it's really important to remain focused on public education on these risks. So that's just one of the things I want to point out that, isn't a legal aspect of it. It's just the impact of these legal changes, what they have on people's risk perception. Now,
absolutely. Do you
there were,
want? I had a question from the pre-submitted questions. There was one for you. Do you want?
oh
Or
no,
do you,
oh no. Okay, I'll do my
yeah.
best.
Can you tell us what are sort of the recommended policies for product testing and clinical specimen testing for hemp and other non-CSA scheduled drugs?
Okay. So the other non-CSA scheduled drugs, I won't have anything to add to that. But I think, for hemp product testing, the key thing to remember is that this is the same plant that is used in our licensed cannabis industries at the state level. It just has a naturally lower level of THC, Delta 9 THC. So I think there's a lot of benefit in looking at the cannabis testing standards that are being used in your state. Because it is the same type of plant, the cultivation is similar. I think the things that, we need to keep in mind is that there's no uniform testing standard, product testing standard for cannabis. There is slight variation between states on what they test for and the amounts of, contaminants that they look for in the product. So I think that's important to note. And it's also important to note, you know, as I mentioned, to turn CBD into THC, the various THC isomers involves heat, acid, and solvents. So, you would probably want to test for any of the solvents that are commonly used in that isomerization process. But I don't think you need to have a hugely different testing protocol than what your state uses for cannabis because, we are dealing with the same plant. All right. So there are a couple questions from the chat that I want us to talk about. One of them was, and I've pulled this up. Someone said, well, why is the level of harm a drug presents incorporated into the rescheduling decision? And George mentioned kind of the three major categories of, potential for abuse, medical benefits, scientific, a couple things. But when the agency actually is doing this rescheduling, they look at, there's stated 8 different factors. And those factors include, not just the actual and relative potential for abuse, but the scope and duration and significant abuse, and what, if any, risk there is to the public health. So in the larger analysis, the potential harms of a substance are considered in that rescheduling decision. So, it's a much more complicated decision process than we can get into today. Um, so I wanted to touch base on that. Now, there were a couple of hemp-related questions that I wanted to get to here. Oh gosh, looking through. Okay. Oh my gosh, there's so many questions now. So someone asked, and this is a farm bill, that it's passed every few years, and since the previous one's lapsed, will there be a new one definitely passed for next year? No. So here is the challenge. With the farm bill, right now, there's a lot of dispute, not just over hemp, but over other things like crop subsidies and the SNAP program, which in the past had been referred to as the food stamp program, are all covered by the farm bill. And right now, Congress isn't looking at a new bill. They realize they have a limited period of time and they're working out an extension of essentially trying to make an extension of the existing farm bill. So that really draws out the timeline where they put an extension in place and then getting to, the 2025 or who knows, 2026 farm bill, depending on, the conflict there, you know, is, draws out the potential decision from a farm bill standpoint. Now, there was a question about the hemp industry. Someone asked, of the $30 billion that the hemp industry, sales in the United States, what percentage is associated with these intoxicating products versus other products like, fiber, paper, cloth, and I can't give you an exact percentage, but I have been in meetings with industry attorneys for the hemp industry, and I know that the intoxicating hemp products are a large portion of that $30 billion. The exact percentage, I'd have to do some research to see what that is, but it is a substantial part of the hemp industry's income. And that's why the industry is very concerned about the very restrictive form of the Farm Bill. All right. George, I'm going to say we do one more question because we've gone almost 15 minutes over.
Fair enough.
And I'm going to look for something that's an easy one so we don't go too far.
Before you do that, I have an extremely quick one. I do want
Okay,
to,
let's do
someone had
that one
asked
and then we
if,
should probably wrap up.
someone had asked if the public comments are available publicly. I believe they are. I've been trying to find them. The Federal Register is very hard to navigate quickly on a time crunch, so I haven't been able to pull it up, but I believe they are available.
George, let's do this for folks. George will find that and include the link in the
Absolutely.
slides so that when the slides are posted, you can go there and it'll take you directly to where they are in the Federal Register.
Perfect.
Awesome. Well, thank you everyone for your time. We really appreciate you joining us today. Please reach out to the network. I'm sorry we couldn't get to everybody's questions today. There was just a lot to cover and a lot of great questions. So have a
Please do
one.
feel free to email us if you have more questions.
Yes, 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 yes. Have a wonderful holiday and please consider attending the network's public health conference. Take care.